Hello and welcome to Unacademy. If you're attempting Prelims 2026, then this is a very important and crucial video for all of you. Expect at least one or two questions from this video, so stay with me till the end, for I'm going to discuss all the non-constitutional bodies in this particular video, all the important ones. How? We will look at when these bodies were created, what is the composition, how the chairperson and members are appointed, is there a selection committee, what is their term, tenure, how can they be removed, and what are the core functions of these bodies. We will not go into the analysis of these bodies. For example, National Human Rights Commission was once termed as the biggest post office in India by Justice V.R. Krishna Iyer. Or this body was termed as the toothless tiger by former Chief Justice of India. But that would be the analysis, because National Human Rights Commission, its recommendations, there is no mechanism for NHRC to enforce its recommendations. But that would be the analysis of NHRC that is relevant for the mains examination. We'll focus on pure concepts and facts in this particular video, strictly relevant for your prelims examination. Nothing more, nothing less. Should you wish that I record a video on all the constitutional bodies, please let me know in the comment section and I promise I will deliver that video. Since less than a month is left for your prelims, this is not the time for panic, but this is the time to revise properly and take as many mocks as possible and analyze your performance, right? And thanks to Unacademy. Now, what Unacademy has done, our prelims test series, which was available at 4,999, for you, it is now available just for ₹1. But this offer is valid only for the next few days till 4th of May. The link is provided in the video description. Please use this opportunity. You will get 46 total tests, 22 full-length, 24 sectional tests, including CSAT. These are good quality questions, strictly according to the UPSC standard. Make the best use of it. The link is provided in the comment section. Enroll at ₹1 and make the best use of this prelims test series. The PDF of the session I will share on my Telegram channel. The link to join my Telegram channel is also provided in the video description. So let's get started and look at body number 1, National Human Rights Commission. But first up, what is a constitutional body? A body which is established by the Constitution. For example, UPSC is a constitutional body. State Public Service Commission is a constitutional body. Election Commission of India is a constitutional body. Finance Commission is a constitutional body. CAG, Attorney General for India, constitutional bodies. Those bodies which are created, established by the Constitution. But then there are some bodies which are not mentioned in the Constitution. We call them extra-constitutional bodies or non-constitutional bodies. But these non-constitutional bodies can further be categorized into two broad groups. Either these extra-constitutional bodies are statutory bodies. And which are these statutory bodies? Those bodies which are created by the law enacted by the legislature. For example, NHRC is a statutory body because it has been created based on a law enacted by the parliament. But then there are bodies which are not created by the law, but they are created by a government resolution. Cabinet issues a resolution and creates a body. For example, NITI Aayog, created under Allocation of Business Rules 1961, not according to the law. So that becomes extra-constitutional, non-statutory body. And in this video, we will focus on all the important statutory, extra-constitutional, non-statutory bodies. First up is National Human Rights Commission. It was established in 1993 based on what law? Protection of Human Rights Act 1993. This body is in conformity with Paris Principles. That means the creation of this body has been established in accordance with the Paris Principles. And what are these Paris Principles? These principles were adopted at an international workshop on national institutions for the promotion and protection of human rights, which was held in 1991 in Paris. Later, it was endorsed by the General Assembly of the United Nations in 1993. What are these Paris principles? For example, we have National Human Rights Commission, which is the watchdog of human rights in India. There are national human rights institutions in other countries as well. Then there is one body which takes a look at all these national bodies of different countries and evaluates them whether they follow these Paris principles or not. And accordingly, they are accredited, whether with A status or B status. We will discuss about that body slightly later because that is important for you for the upcoming examination because of a controversy. Long story short, NHRC is a statutory body created under a law enacted by the Parliament, and this is done in accordance with Paris Principles. These Paris Principles basically say that all these national human rights institutions of other countries, different countries, which act as the watchdog of human rights in their respective countries, whether they are independent of the government, because government has the potential of violating the fundamental rights and the human rights of the citizens. So there should be an independent watchdog to keep a check on the government to ensure that they do not violate the human rights of the citizens. For that, this body has to be independent of the government. It should have sufficient personnel. It should have sufficient funding. It should also be plural in its membership and composition. On these basis, whether these conditions and principles are being followed by human rights institutions of different countries, that is how a body accredits them, evaluates them, and accordingly gives them a rating. We will discuss that. But this act provides for National Human Rights Commission at the national level, state human rights commissions in all the states, as well as human rights courts. Number one. Number two, who is going to be the chairperson of NHRC? Previously, the law said whoever has been the former Chief Justice of India is eligible to be appointed as the chairperson of the NHRC. But the year was 2019, the law was changed. And according to 2019 amendment, now the chairperson of the NHRC can be either a former judge of the Supreme Court or a former judge of the High Court. Former, which means retired, not the sitting one. Because there are some bodies where even sitting judges can be appointed. Which are these bodies? We will discuss later. But for this NHRC, the chairperson has to be either former Chief Justice of India or a former judge of the Supreme Court. What is the composition of NHRC? Now this is where it becomes interesting. Apart from chairperson, we will have a sitting or former judge of the Supreme Court. Sitting judge of the Supreme Court can also be a member of NHRC. But what about former Chief Justice of a High Court or sitting Chief Justice of a High Court? You can be another member. And then there are three other members. At least one has to be a woman. Which means what is the composition of NHRC? We will have a chairperson who has been the Chief Justice of India or a judge of the Supreme Court. And then there are members. One member, former or sitting judge of the Supreme Court. Another member, former or sitting Chief Justice of a High Court. Chief Justice. Former judge can be a member of the Supreme Court. Former Chief Justice or a sitting Chief Justice can be a member of NHRC. And three members, at least one will be a woman. But then there are ex officio members as well. Ex officio members in the sense, whoever is the chairperson of the National Commission for Scheduled Castes becomes the member of the NHRC. Ex officio, by virtue of you holding the post of the National Commission for Scheduled Castes chairperson, you are the member of the NHRC. Which are these other bodies whose chairperson is the ex officio member of NHRC? National Commission for Scheduled Tribes, National Commission for the Backward Classes, National Commission for Women, National Commission for Minorities, National Commission for the Protection of the Child Rights, and Chief Commissioner for Persons with Disabilities. Whoever is holding these positions, they become ex officio members of NHRC. But how is this chairperson and member appointed? And who appoints them? appointed by president by warrant under his hand and seal. That means the president cannot delegate this responsibility of appointing the chairperson or the members to someone else. President has to appoint the chairperson and the members. But does president appoint chairperson and members on her own? No. She follows the recommendation of a committee. Now this is where it becomes even more important. Who is the member of this committee, on the basis of which the president appoints the chairperson and members of the NHRC? What is that composition? It consists of Prime Minister as the chairperson, Speaker of the Lok Sabha, Minister in charge of the Home Affairs, that means Home Minister, Leader of the Opposition in House of the People, Leader of the Opposition in Rajya Sabha as well, plus Deputy Chairperson of the Council of States. Which means for NHRC, you have to keep in mind that Vice President of India, the chairperson of the Rajya Sabha, is not the member of this committee. Prime Minister is, Home Minister is, Speaker is, Leader of Opposition in both the houses, Deputy Chairperson. Which means Speaker of Lok Sabha, Deputy Chairperson of the Rajya Sabha, that is the composition of this committee. Very, very, very important. But now look at this important detail. If a sitting judge of the Supreme Court, because sitting judge of the Supreme Court can become the member, can be appointed as the member of the NHRC, as well as sitting Chief Justice of a High Court can also become a member. Provided a sitting judge of the Supreme Court or a sitting Chief Justice of a High Court is to be appointed as the member of the NHRC, you have to consult the Chief Justice of India. Which means what? In appointing former judge of the Supreme Court, former Chief Justice of a High Court, you don't have to consult the Chief Justice of India. Right? These are important facts. The original act, which was passed in 1993, it said that the chairperson and members of NHRC as well as the SHRC, State Human Rights Commission, because State's Human Rights Commission chairperson can be a former Chief Justice of a High Court or a former judge of a High Court. And you are appointed by the governor of that state. But the law said, original law, 1993 Act, it said that this chairperson and these members will be appointed for a period of 5 years or till they attain the age of 70, whichever is earlier. Now, what do we mean by 70 or 5 years, whichever is earlier? I will explain this now because we will frequently encounter this phrase throughout this video. For example, my age is 40. That's not my age, by the way. I'm still in my sweet 18. But let's assume my age is 40. Can I be appointed as the chairperson of the NHRC, for example? Will I remain in office till the age of 45? Or will I remain in office till the age of 70? Which means for the next 30 years, will I continue as the chairperson of the NHRC? No. Either 5 years or 70 years, whichever is earlier. Which means if my age is 67, now I am appointed as the chairperson of the NHRC, I can continue to hold the office only for the next 3 years. Because in the next 3 years, I will cross 70. So this is the upper age limit. But 2019, when this law was amended, this term of the chairperson and members was reduced to 3 years. Previously, it was 5 years. Now it is reduced to 3 years. 3 years or till the age of 70, whichever is earlier. Now, can these members be reappointed? Can the chairperson be reappointed? That's the question on your mind. Because once you are appointed, can you be reappointed? Previously, reappointment was allowed. Under the original Act of 1993, reappointment was allowed. And reappointment was done for a period of 5 years. But in 2019, this 5 year was removed. Which means, listen to me carefully, can the members of the NHRC be reappointed? Yes, but not necessarily for 5 years. This 5 year limit has been removed from reappointment, which means you can be reappointed for a year, 2 years, 3 years, subject to you meeting this upper age limit of 70. These are crucial facts relevant for your examination. Another crucial fact: once you cease to hold the office as the chairperson or the member of the NHRC, you are ineligible for further employment either under the government of India or government of any state. You are ineligible for further employment. But can you be appointed as a governor? Yes. Can you contest elections? Yes. But for further employment under the government? No. That is ineligibility. Former Chief Justice of India, former Judge of the Supreme Court, as I told you, Justice V.R. Krishna Iyer, he called NHRC as the biggest post office in India. But sir, you said you will not be analyzing these institutions. I'm not analyzing. I'm just saying this so as to tell you what is the role of this committee. The role of this NHRC is to be, in one way or the other, the watchdog of human rights in India. But it can only suggest recommendations. But these recommendations are not binding on the government. So NHRC can, on its own, conduct investigation, on its own, conduct surveys without somebody approaching it. But then whatever they recommend, it is not binding on the government. And that is why V.R. Krishna Iyer said, NHRC is like a post office. It receives a complaint from somebody who has alleged violation of human rights. Then NHRC submits this complaint to the government authorities seeking their reply. And whatever reply they get, they forward these replies to the complainant. So what is your role? Whatever you recommend, whatever you suggest is not binding on the government. That is the biggest loophole or the drawback or the disadvantage or the flaw in NHRC. This is National Human Rights Commission. But now, important thing. How free or fair is India's National Human Rights Commission? This question is under international review. By whom? By this Global Alliance of National Human Rights Institutions, GANRI. What it does, it takes a look at all the national human rights institutions of the world and then evaluates them whether they are following Paris principles or not. If you follow Paris principles, you are given A rating. If you don't follow Paris principles, you are given B rating. Our NHRC was up for review because every 5 years there is a review of these national human rights institutions. Since inception, our NHRC was given A rating by this Global Alliance. But now for the past few years, it is under challenge. Challenge in the sense, Amnesty International and various other institutions of the world, they have approached this Global Alliance saying, don't give A rating to India's Human Rights Commission. Why? Because the composition of this committee lacks diversity. It is not independent. It is under the control of the government. Former police officers have been appointed as the members of this commission. Because police officers are allegedly violating fundamental rights, how can these police officers be members of the NHRC? They have been unable to respond to escalating human rights violations in India. Whether true or not, we don't have to get into that. Long story short, this review was pending. But last year, this Global Alliance's subcommittee on accreditation, what it did, it recommended that NHRC status be downgraded from A to B. That means it is not fully compliant with Paris principles. It is partially compliant. But then we have approached the Global Alliance. We are seeking a review, which means right now it is under review by this body. Although subcommittee had recommended downgrading the status of NHRC from A to B, but we have challenged it. The final verdict on this will be delivered in November 2026. Till that time, you keep in mind that our status is under review. The status of NHRC is under review. Then what happens if NHRC is given B status? Then NHRC, it can participate in the meetings of this Global Alliance, but it cannot vote or hold any governance positions in this body. That's a big blowback against NHRC. But these facts are important. This completes our topic number 1, NHRC. Now, second is Central Information Commission. This is a statutory body created under the Right to Information Act, a landmark act on transparency enacted by the Parliament in the year 2005. You would know RTI. You file an RTI application if you need information from a public body, and then they will have to furnish the information. You're not satisfied with this information. If it's a central department, central government department, you file a petition before Central Information Commission, and the decision of the CIC is final. Obviously, it can be challenged in the courts. If you're not satisfied, you can go to the courts as well. But although its decision should have finality. But be that as it may, what is the composition of this Central Information Commission? It consists of Chief Information Commissioner and such number of Central Information Commissioners as may be deemed necessary. But is there a limit? Not exceeding 10. That means we will have Central Information Commission, which is a statutory body created based on the law enacted by the Parliament, the Right to Information Act 2005. Composition is that we will have a Chief Information Commissioner and as many information commissioners as possible, subject to this limit 10, not more than 10. But who will appoint them? President. President on her own? No. Based on the recommendations of a committee. What is the composition of this committee? If you have to appoint the chairperson and members of National Human Rights Commission, for that you have the Prime Minister, you have Home Minister, you have the Speaker of Lok Sabha, Deputy Chairperson of the Rajya Sabha, Leader of the Opposition in both the houses, Lok Sabha as well as Rajya Sabha. But for this Central Information Commissioner and Information Commissioners, for that we have Prime Minister, who is the chairperson of this committee, Leader of the Opposition in the Lok Sabha, and Union Cabinet Minister nominated by the Prime Minister. So Home Minister is not part of it because you are a Home Minister. Home Minister is part of it because Home Minister has been nominated by the Prime Minister. This fact is important. This differentiation is important. But this Chief Information Commissioner and Information Commissioners, they shall be persons of eminence in public life. They should have knowledge, experience, expertise in either law or journalism or mass media or administration, can be bureaucrats as well. But this Chief Information Commissioner and Information Commissioner shall not be the member of the Parliament or member of any state legislature or a union territory, cannot hold any office of profit, cannot be connected with any political party, cannot be carrying on any business or pursuing any profession. Because if you do that, then you are ineligible. That means you don't have to be a member of the Legislative Assembly, member of the Legislative Council, member of the Rajya Sabha or the Lok Sabha, member of a Union Territory's Legislative Assembly, or holding any profession. And then you can be appointed as the Central Information Commissioner or Information Commissioners. Clear? What is the term? The term of the chairperson of the NHRC is 5 years or till you attain the age of 70, whichever is earlier. But what is the term of the CIC and Information Commissioners? That term will be prescribed by the central government. Which means when the central government will appoint you, they will specify that you are appointed for a 3-year term or you are appointed for N term. But this term is not prescribed in the law. But what is prescribed is upper age limit, 65 years, provided that no Chief Information Commissioner shall hold office after he or she has attained the age of 65 years. Similarly, Information Commissioner also, you will hold that term as may be prescribed by the central government and till the age of 65. Now listen to me carefully. I am an Information Commissioner. Can I be reappointed as Information Commissioner? No. No. But I am an Information Commissioner. Can I be appointed as the Chief Information Commissioner? Yes. But what if you are appointed as Information Commissioner? Now you are Chief Information Commissioner as well. The law said combined tenure cannot be more than 5 years. Which means you may be appointed as Information Commissioner. Can you be further appointed as the Information Commissioner? No. But can you be elevated to that of the Chief Information Commissioner? Yes. But your combined term at the Information Commission, at the Central Information Commission, should not be more than 5 years. These facts are extremely important. But once this Chief Information Commissioner or Information Commissioner are appointed, can they be removed? Yes. On what grounds? Numerous grounds. But for different ground, different mechanism of removal. So what are you trying to say? I'm saying if you are to be removed on the grounds of proved misbehavior or incapacity, then the president cannot remove you on her own. President will have to refer this matter to the Supreme Court of India. Supreme Court of India has to conduct an inquiry, and basis that inquiry, Supreme Court has to come up with a report that this particular CIC or Information Commissioner indeed has resorted to misbehavior, or he does not have the capacity to continue further. Then you can be removed. So this is one ground. If you are to be removed on the grounds of proved misbehavior or incapacity, matter has to go to the Supreme Court for an inquiry. But you may be removed on other grounds also. President thinks that because of infirmity of mind or body, you are incapable of continuing further, can remove you. Or you have been declared bankrupt, or you have been convicted by a court for any offense involving moral turpitude. For example, you have been convicted for rape, for sexual harassment. In that case, you can be removed. But if you are to be removed on these grounds, please listen to me carefully. President need not refer this matter to the Supreme Court. On these grounds, there is no need to go to the Supreme Court for an inquiry. The need to go to the Supreme Court for an inquiry only arises if the CIC or Information Commissioner is to be removed on the grounds of proved misbehavior or incapacity. This is body number 2. Now body number 3, Lokpal. The famous Anna Hazare movement on India against corruption. And that's how this law was enacted. Pursuant to Article 253 of the Constitution. Article 253 says if the country has ratified an international agreement or a treaty, for example, we ratified United Nations Convention Against Corruption in 2008. And when you ratify a convention, it is obligatory on you to establish systems in place, to put systems in place which can control corruption. And basis that, under Article 253, Parliament becomes empowered to enact a law to give shape, effect to any international agreement or a treaty or a convention that you have signed. And that's how Lokpal was born. And this law was Lokpal and the Lokayuktas Act 2013. Lokpal at the national level, Lokayukta at the state level. But sir, the question is, how can Parliament enact a law for the states? Why is Parliament enacting this law called the Lokayuktas Act? Because it is under Article 253. Whenever you have to give shape to an international agreement, treaty, convention, then Parliament becomes empowered to make a law, even if the matter is in the state list. Lokpal and the Lokayukta Act of 2013. What is the composition? Lokpal is not one individual. Lokpal is an institution. And this institution of Lokpal consists of chairperson. But who is this chairperson going to be? Can a sitting Chief Justice of India be a Lokpal, chairperson of Lokpal? Yes, very important fact. Extremely relevant for your examination. Because the Lokpal will have a chairperson who is or has been a Chief Justice of India, or who is or has been a judge of the Supreme Court, but not necessarily only a retired judge or a retired Chief Justice or a sitting Chief Justice or a sitting judge is appointed as the chairperson of the Lokpal. You can also be an eminent person who is or has been the Chief Justice of India, who is or has been the judge of the Supreme Court, or an eminent person. You are the chairperson of Lokpal. Are there other members? Yes. How many? Not exceeding 8. Which means we will have a chairperson of Lokpal. We may have 8 members. But 4 members should be judicial members. And who are these judicial members? I'll tell you slightly later. Provided that not less than 50% of the members of the Lokpal be from the persons belonging to the scheduled caste, scheduled tribe, OBCs, minorities, women. That means if you have 8 members who are part of Lokpal, apart from the chairperson of the Lokpal, at least 4 of them should be from minorities, women, SCs, STs, backward classes. What about a judicial member? So you said half of these members have to be judicial members. What do we mean by judicial members? If you are to be appointed as the member of the Lokpal in judicial capacity, as a judicial member, then you have to be a judge of the Supreme Court. Whether sitting or retired, doesn't matter. Sitting judge as well as retired judge of the Supreme Court can be a judicial member of the Lokpal. Or you have to be a sitting Chief Justice of a High Court or a former Chief Justice of a High Court. You are the judicial member of the Lokpal. Apart from judicial members, we have other members, non-judicial members. Half of them have to be judicial members. The remaining half have to be non-judicial members. Who are these non-judicial members? Men and women of integrity. Outstanding ability. But they should have experience. Not less than 25 years of experience in matters related to anti-corruption, matters related to banking, law, management, administration, former IS officers, public policy. This is what you have to keep in mind. The chairperson or a member shall not be a legislator or a member of a local body. You cannot be a person who has been convicted of any offense involving moral turpitude. Convicted, not accused, convicted. Less than 45 years of age. This question was asked in one of the prelims examination, and it stumbled students that UPSC can go so deep into this topic, but that's how it is. And a person who has been removed or dismissed from the services of the union or the state. So we have chairperson of the Lokpal and not more than 8 members of the Lokpal. Half of them have to be judicial members. Half of them have to be non-judicial members. At least 50% have to be the members belonging to SC, ST, OBC, minorities, women. But then who this chairperson and member has to be? You cannot be a legislator or a member of any local body, panchayat or municipality. You can't be somebody who has been convicted of any offense involving moral turpitude. You cannot be somebody who is less than the age of 45. And you cannot be somebody who has been removed or dismissed by the center or the state government. Then, how are you appointed? All the members and chairperson are appointed by president. On her own? No. Based on the recommendations of the selection committee. Who appoints? For what term? How are you removed? On the basis of the recommendations of which committee? These are crucial details for your prelims examination. Selection committee consists of Prime Minister as the chairperson, Speaker of the Lok Sabha, Leader of the Opposition in the Lok Sabha, the Chief Justice of India or a judge nominated by the Chief Justice, one eminent jurist nominated by the President. But sir, how do we remember this? because this committee is different for different institutions. Keep in mind and listen to me carefully. Normally, you may be taught tricks that use this acronym and remember, but tricks don't work. Conceptual clarity works. Because tricks you may forget, but conceptual clarity you won't forget. Now, what is that conceptual clarity? A law, I don't know how many amongst you would know when this law was enacted, how the country was protesting at Ramlila Maidan in Delhi, launched by Anna Hazare and others. So this was a humongous movement in the history of independent India, where the civil society came together to press the parliament to enact a strong anti-corruption ombudsman known as the Lokpal. At that time, there were ferocious debates in the parliament. How can there be a body which can keep a check on the prime minister also? Which means the selection committee has to be more representative. It has to involve top people. Top people, Prime Minister. Top people, Chief Justice of India, eminent jurist, as well as members of the legislature. Which means this body should be representative of civil society, judiciary, executive, legislature. Because this was a watershed moment in the history of independent India. And that is how you have to keep in mind. For such body, Lokpal, the selection committee has to be top notch. It should have the membership from civil society, judiciary, executive, legislature. That's how you can keep in mind. Chairperson and members, their term is now 5 years. Or till the age of 70 years, whichever is earlier. Now, don't ask me again, sir, what do we mean by till the age of 70 or 5 years, whichever is earlier, because I've explained it. But you may also resign. How can you resign? You can resign by submitting your resignation to the president. Because president has appointed you, you have to submit your resignation to the president if you want to resign from the Lokpal. Or you may be removed from your office. On what grounds? Misbehavior. On the grounds of misbehavior. But here also, the matter has to go to the Supreme Court. Supreme Court will have to conduct an inquiry whether the allegation against this Lokpal member or chairperson involving misbehavior, whether these are proven or not. Misbehavior. But whatever report is given by the Supreme Court, that becomes binding on the president. Ought to be removed on such ground. But there can be other grounds where I don't have to necessarily go to the Supreme Court for inquiry. Which are those other grounds? For example, we discussed that in NHRC. What are the other grounds in case of Information Commissioners, Central Information Commissioner? What are the other grounds? If you have been declared insolvent, if you engage in paid employment outside your office, you are Lokpal member or a chairperson and you are pursuing job in other area also, then there seems to be conflict of interest, you are gone. Or in the opinion of the president, you are ineligible to continue, unfit to continue because of infirmity of mind or body. Maybe you have turned insane, or maybe you have suffered some accident, you have witnessed, you've been subjected to an accident because of which you are in a state of, you are comatose, which means body has been physically paralyzed, you are physically unfit to continue. In that case, you will be removed. But we don't have to send a matter to the Supreme Court for an inquiry, because that inquiry is only if the allegation is that of a misbehavior. For these other grounds, there is no need for a Supreme Court inquiry. For Lokpal, we need to go even deeper. Deeper in the sense that the salary, allowances and other conditions of service, the chairperson will have the same salary as that of the Chief Justice of India. But for other members, it will be same as the judge of the Supreme Court. Just like Election Commission of India will have Chief Election Commissioner and election commissioners. But for them, the status for all of them is same as that of the judge of the Supreme Court. But there was a time when the status of the CEC was that of the judge of the Supreme Court, and the status of ECs was that of the judge of a high court. But that's not the case here. The chairperson will have the same salary as that of the Chief Justice of India. Other members of the Lokpal, they will have the same salary allowances as the judge of the Supreme Court. But now listen to me carefully. Another interesting, important detail. Once you cease to hold office, whether you are a chairperson of Lokpal or a member of Lokpal, you are ineligible. Ineligible for what? For reappointment as the chairperson or member of Lokpal. You cannot. Can a chairperson of Lokpal be reappointed as the chairperson of the Lokpal? No. Can a member of the Lokpal be reappointed as the member of the Lokpal? No. Can you be sent to any diplomatic assignment? For example, let's assume that Mr. Dinesh Trivedi, who was a bureaucrat, then a minister, eminent person. Can an eminent person be appointed as the chairperson of the Lokpal? Yes. But after appointment, can then Mr. Dinesh Trivedi be sent to Bangladesh as India's envoy? No. But I'm not saying Mr. Dinesh Trivedi was the Lokpal. I'm just saying that once you cease to hold that office, you are ineligible for any diplomatic assignment. Can you be sent as the governor? No. Can you be sent as an administrator of a union territory? No. Can you be eligible for any employment? No. Can you even contest election to the post of the president, vice president, member of the parliament, municipality? No. But there is a cooling off period. Cooling off period in the sense, for 5 years after you have relinquished your post, you are ineligible to even contest elections. After that, you can contest elections. After the 5-year term is over. 5-year cooling off period is over. But sir, can the member of the Lokpal be appointed or reappointed as the member of the Lokpal? No. But can you be appointed as the chairperson of the Lokpal? Yes. Provided your combined term is not exceeding 5 years. That means your combined term as the Lokpal chairperson and the member of the Lokpal does not exceed 5 years. These facts are important. Another important fact. Whatever expenses of Lokpal, those are charged on the Consolidated Fund of India. Charged on Consolidated Fund of India, that means not subject to the vote of the Lok Sabha. Charged expenditure. For whom? Whether it is chairperson or members or secretary or any other officer or staff of Lokpal, all their salaries, allowances, even pensions are charged on the Consolidated Fund of India. This is to ensure the independence of the office of Lokpal chairperson, members and the staff. But what is their jurisdiction? What do they basically do? They may inquire and investigate the Prime Minister, ministers, members of the Parliament, Group A, B, C, D officers, officials of the central government. That is why we say it is like an ombudsman. You have a complaint against the Prime Minister, against the ministers, MPs, Group A, B, C, D officers of the central government, you go to Lokpal. You have a complaint against the Chief Minister, MLAs, ministers at the state level, Group ABCD officers at the state level, you go to the Lokayukta. That's the jurisdiction. But there are some areas of Prime Minister where Lokpal cannot inquire. For example, international relations, external internal security, public order, atomic energy, space, which means if you have any knowledge or you have an allegation that the Prime Minister is involved in corruption when it comes to our external or internal security or dealings in our international relations, you cannot approach the Lokpal. Lokpal does not have that jurisdiction. And if you want to inquire Prime Minister, for that Lokpal or if you want to inquire against Prime Minister, for that, when you complain to the Lokpal, Lokpal will have to set up, the chairperson of the Lokpal will have to set up the full bench of the Lokpal, which means the chairperson of the Lokpal as well as all the 8 members. And 2/3 of these members, they will have to approve an inquiry. Once they approve the inquiry, only then you can investigate the Prime Minister. Because after all, we have to keep Prime Minister at a higher pedestal as compared to anyone else. Not just that. You know there is Article 105 of the Constitution. Anything that you say inside the Parliament as a member of the Parliament, or any word that you give, you cannot be held accountable in any court of law. That's the privilege available to a member of the Parliament. Can Lokpal be invoked by anyone that a particular member of the Parliament has said something inside the Parliament, or any word that he has given inside the Parliament, and we want you to inquire into that? No, you can't do that, because this involves the privilege of the parliamentarians. Lokpal is beyond it. Can Lokpal have jurisdiction over members of the judiciary? This is where it became controversial last year when Lokayukta, or when the Lokpal, Justice Khanvilkar is the chairperson of the Lokpal, when the Lokpal said that judges of the high courts can come under the jurisdiction of the Lokpal. Immediately matter went to the Supreme Court. Supreme Court stayed this. Supreme Court said no. You cannot be subjecting members of the judiciary, judges of the High Court or Supreme Court, to Lokpal. Lokpal is only for Group A, B, C, D, Prime Minister, ministers, members of the Parliament, officials of the central government, but not for the members of the judiciary. So maybe a conceptual statement is given in the examination. Lokayuktas can inquire into the allegations of corruption against the High Court judges. Since Justice Yashwant Verma is in the news, Lokayukta was in the news, Lokpal is in the news, this statement is incorrect. Okay? Let's look at another important body, Central Vigilance Commission. Central Vigilance Commission is a very important governmental body. And the responsibility of the CVC is that you promote integrity, transparency, accountability in country's public administration. You might have heard or read that whenever there is an employee of the government, they say we have to go to the office quickly today, early today, because there is a vigilance raid happening. Vigilance, you keep the government officials under check to ensure that they are not indulging in any corruption. Who recommended CVC's establishment? CVC is Central Vigilance Commission. That means for central government employees, keep a vigilant check on them, that they should ensure transparency, that they do not resort to corruption. Who recommended this body? Santhanam Committee on Prevention of Corruption, way back in 1964, recommended CVC. But CVC was not given a statutory status. You can say it was neither mentioned in the Constitution nor in any law enacted by the Parliament, but it was created by a government resolution. But CVC was given a statutory status in 2003, Central Vigilance Commission Act. An act enacted by the Parliament gave statutory status to Central Vigilance Commission. Okay? But the Central Vigilance Commissioner and Vigilance Commissioners, they shall be appointed by whom? By the President, by warrant under his hand and seal. But on the recommendations of a committee. This committee consists of Prime Minister, Union Minister of Home, and Leader of the Opposition in the House of the People. And whenever there is no Leader of the Opposition in the House of the People, Leader of the single largest party in Lok Sabha. This committee comes together and recommends to the president who should be the CVC and vigilance commissioners. But sir, in case of Lokpal, you gave us a hint, a conceptual clarity how to remember the selection committee. For CVC, what should we remember? Again, no trick, conceptual clarity. At one point, CVC PJ Thomas was appointed as the CVC. Meeting took place. Dr. Manmohan Singh was the Prime Minister, Mr. P. Chidambaram was the Home Minister, and Ms. Sushma Swaraj was the leader of the opposition. Shrimati Sushma Swaraj protested, saying, no, I don't want PJ Thomas to be appointed as the Chief Vigilance Commissioner because his track record is not right. He is an accused in a particular corruption case, Pamalu case in Kerala. Despite those objections by Sushma Swaraj, PJ Thomas was appointed. Later on, the matter went to the Supreme Court. At that time, Sushma Swaraj said that these two individuals, they did not listen to me when I raised the objections against PJ Thomas. P. Chidambaram, Dr. Manmohan Singh, two members, and leader of the opposition in the Lok Sabha, another member. This case, if you can keep in mind, and whenever CVC is asked, you will be able to identify that, okay, at that time it was Mr. Chidambaram, Dr. Manmohan Singh, and Sushma Swaraj, and that is the composition of this committee. What is the term? Chief Vigilance Commissioner holds office for a term of 4 years or till the age of 65, whichever is earlier. And CVC, once appointed, once your term is over, can you be reappointed? No, you cannot be appointed again. But then apart from the CVC, there are vigilance commissioners. They also hold office for the 4-year term or till the age of 65, whichever is earlier. Because the composition will be, we will have CVC, we may have vigilance commissioners. And for CVC, the recommendation and the vigilance commissioners, the recommendation has to come from this committee. Again, all these statutory bodies basically, once appointed, you can be removed by the president because president has appointed you. On what grounds? On the grounds of proved misbehavior or incapacity. But here also the matter has to go to the court. Which court? Supreme Court. Supreme Court will have to conduct an inquiry and see and inquire whether the allegations of misbehavior or incapacity have been proven against the CVC and the vigilance commissioners. And basis that report, you may be removed. But you may be removed on other grounds also. Just like we discussed previously, adjudged insolvent. You have been convicted by the court for an offense involving moral turpitude. You have engaged in paid employment outside your office. You are unfit because of the infirmity of mind or body. In that case, you can be removed, but this time there is no need for this matter to be sent to Supreme Court for an inquiry. Even without the Supreme Court inquiry, you can be removed. Body number 5, National Commission for Minorities. Doesn't have a chairperson right now. Doesn't have a vice chairperson, if I'm correct right now. Recently, a member was appointed. There was a petition in the court that you should fill the vacancies in the National Commission for Minorities. Very important body considering the civil services prelims examination. But look at the history. This National Commission for Minorities, its origin is that initially it was an attached office of MHA, Ministry of Home Affairs. So do we have to go so deep into details? Sometimes yes, for some specific bodies. For example, once a question was asked whether the ethics committee was an ad hoc committee initially, privileges committee, so on and so forth. These facts become important. You know the PYQs, you will understand the significance of these facts. It was established in 1978, but first as an attached office of the Ministry of Home Affairs. Then in 1984, it was placed under the Ministry of Welfare. And in 1984, new Ministry of Welfare was set up. But when we say minority, Constitution under Article 30 talks about 2 sets of minorities. All minorities, whether based on language or religion, They will have the fundamental right to establish, manage, administer educational institutions of their choice. So minorities can be either religious minorities, linguistic minorities. So this National Commission for Minorities, does it deal with linguistic minorities and religious minorities, or only religious minorities? Previously, it used to deal with both religious minorities, linguistic minorities. But linguistic minorities, they were excluded from its ambit in 1988. And then in the year 1992, this National Commission for Minorities, which initially started as an attached office of the Ministry of Home Affairs, which means it was not a statutory body. It was given a statutory status in 1992, but it was not born in 1992. It was given a special statutory status in 1992. Its origin dates back to 1978, when Janata Party was in power, not the Congress. Who are the minorities? Initially, in 1992, Muslims, Christians, Sikhs, Buddhists, Parsis were declared as minorities under the ambit of National Commission for Minorities. In 2014, Jains were added. So 1, 2, 3, 4, 5, 6. These are 6 nationally recognized religious minority groups in India. What is the composition of the National Commission for Minorities? It will have a chairperson, vice chairperson, 5 members. Now listen to me carefully. What does the law say? Very carefully. Very important point. Technical point. Listen to me. Chairperson and these members, they have to be from minority communities, which means Muslims, Christians, Sikhs, Jains, Buddhists, Parsis. Muslims, Christians, Sikhs, Buddhists, Jains, and Parsi. These are the 6 religious minorities, which means chairperson and members have to be from these minority communities. What about the vice chairperson? Vice chairperson may not be from minority community, but chairperson and 5 members, they have to be from minority communities. What is their term? Term is 3 years. They can be removed also. Removed on various grounds: moral turpitude, adjudged insolvent, so on and so forth. But one important detail is, if the chairperson or the members, they remain absent from the meetings of this commission for 3 consecutive meetings, you are removed. You are liable to be removed. And this National Commission for Minorities has the power of a civil court. Civil court in the sense, assume I am the court, civil court. I can seek your attendance. I can seek the display of papers. I can call in the witnesses. So that's the power of the civil court. I can summon the attendance of individuals. I can summon the officials. Normally, there are commissions which submit annual reports, right? But National Commission for Minorities makes periodical or special reports to the central government. This law does not talk about annual reports. It talks about periodical or special reports submitted to the central government. This is the composition and the chairperson. And who appoints them? Central government. Does that mean President will have to necessarily appoint these chairperson and vice chairperson and members? No, not by his warrant under his hand and seal. Central government can issue a notice and can issue a notification and say, these are the members, chairperson, vice chairperson of National Commission for Minorities. Body number 6, National Commission for the Protection of the Child Rights. This law was enacted when? In the year 2005. That means it is a statutory body. It talks about National Commission for the Protection of the Child Rights. It also talks about state commissions for the protection of the child rights. What is the composition of the NCPCR, National Commission for the Protection of Child Rights? It will have a chairperson and 6 members. At least 2 have to be women. Appointed by central government. It doesn't say appointed by president, appointed by the central government, which means president need not appoint you. Central government will issue a notification and you're appointed. But this chairperson of the NCPCR is appointed by the central government on the recommendations of a 3-member committee, and this 3-member committee is headed by the Minister of Women and Child Development. So it does not involve leader of the opposition, chief justice, prime minister, home minister. No. National Commission for the Protection of the Child Rights. Chairperson and members. Chairperson and 6 members. At least 2 should be women. But chairperson specifically can be appointed by the central government on the recommendations of a 3-member committee, which will be headed by the Ministry of Women and Child Development. 2 others can be experts. What is their term? 3 years. Can they be reappointed? Yes. This is where reappointment takes place. But reappointment not for more than 2 terms. There is a limit. Chairperson holds office till the age of 65 years. Members hold office till the age of 60. This differentiation is important for National Commission for the Protection of the Child Rights. And what is your role? Basically, your role is to see how children can be protected, what are the legal safeguards for them, whether those safeguards are being met, whether the conditions are conducive for their growth and development. But very important role that this National Commission for the Protection of the Child Rights performs is that there are children who are affected by terrorism or communal violence or domestic violence or HIV/AIDS. And because they come under these circumstances, they are more vulnerable children. And because they come from the vulnerable sections of the society, it may also impact the enjoyment of their rights. What are the remedies that we can prescribe so that these children can enjoy the rights? Because these children come from different sections of the society, affected by terrorism, domestic violence, HIV/AIDS, torture, pornography, prostitution. Recommend measures for these children. That's the role of the National Commission for the Protection of the Child Rights. 7th body, CBI. CBI comes under Department of Personnel, Pension and Grievances. It's one of the premier investigative agency in the country. What is the origin? The origin is during the British rule, 1941 and 1941, what happened? There was a Second World War between 1939 to 1945. During this war, we need to supply various stuff, food, grains, medicines, other stuff, maybe weapons as well. It was alleged that there is corruption involved with the war supplies. The then government set up special police establishment under the Deputy Inspector General of Police by an executive order. So it was not a statutory body. By an executive order, this body was set up. Why? You just inquire and investigate the corruption in, bribery in the war transactions. And then these supplies were moved from one part of the country to another part of the country through railways. Then the government said this special police establishment will not only investigate the central government employees regarding these war supplies, bribery, will also investigate the railway employees, because railways have been strategically used to transfer these war supplies from one part of the territory to another. And that is how the special police establishment came into being. But the war got over, 1945, and the government felt that this department did a spectacular job investigating bribery allegations during the war time. We need to continue with this committee. We need to continue with this body. And that's how Delhi Special Police Establishment Act was brought into force after the Second World War got over. And then this Special Police Establishment, which was previously under Deputy Inspector General of Police, it was placed under the Home Department. And now you don't have to only investigate the War and Supply Department or railways. You can investigate corruption allegations against any central government employee. Central government employee. Can CBI be used to investigate the state government employees? For that, state government's consent is required. And state government gives general consent or specific consent. Specific consent, only for this particular case, CBI can investigate. Or general consent, on any case, you come and investigate, even our employees, doesn't matter. But sir, it is Delhi Special Police Establishment. How did it get this name, Central Bureau of Investigation? In 1963, through a Home Ministry resolution. And slowly and steadily, its ambit became broader. When the banks were nationalized during Indira Gandhi's tenure in 1969, now the employees of the central public sector banks also came under the ambit of the CBI. CBI is headed by director. But CBI director is appointed by center on the recommendations of a 3-member committee, because CBI has been referred to as a caged parrot, parroting the words, thoughts of the political masters in the central government. Because of the Arvind Kejriwal issue, the liquor Delhi excise issue, CBI is in the news. CBI director is appointed by the central government based on the recommendations of a committee. Committee consists of Prime Minister, Leader of the Opposition in the Lok Sabha, Chief Justice of India, or a Supreme Court judge nominated by him. So how do we know then? How do we remember that CBI is part of this or not? Who called CBI caged parrot? Supreme Court. Supreme Court Chief Justice is part of it. Part of this committee to recommend to the central government who should be appointed as the CBI director. But what is the term? In Vineet Narayan case, Supreme Court said the minimum term of the CBI director has to be 2 years. Minimum he can be appointed for 2 years, but maximum he can be appointed for is 5 years, which means he can be given extensions. He is appointed for 2 years, but he can be given 1 year extension, then another 1 year extension, then another 1 year extension, so that together 2 years plus 3 extensions, your combined term cannot be more than 5 years. Another important body, Directorate of Enforcement, ED as it is called. ED was previously under Department of Economic Affairs under the Finance Ministry. This is when it was known as the Enforcement Unit. 1957, this unit was renamed as Enforcement Directorate or Directorate of Enforcement, and now it was placed under the Department of Revenue. What is the role? The role is to investigate money laundering allegations, violation of the foreign exchange laws, including cryptos. Can cryptos be used to launder money? For example, a lot of people, they do send money abroad using, now why do I reveal it? I'll keep it separate. So the point is cryptos. Can cryptos be used to launder money? Yes. If yes, then Department of Revenue, ED, can investigate and inquire into these allegations. Principal law that this ED deals with is PMLA, Prevention of the Money Laundering Act 2002. Right? But how is this ED director appointed? The central government shall appoint the Director of Enforcement based on the recommendation of a committee. This committee, unfortunately, does not have the political bosses participating. Central government appoints, but based on the recommendation of the CVC, Vigilance Commissioners, Secretary to Home Ministry in the Ministry of Home Affairs, Secretary who is in charge of the Ministry of Personnel, in the DOPT, and secretary to the Government Department of Revenue, because ED comes under Department of Revenue. The secretary of that is a member of this committee to recommend to the central government who should be the director of the ED. In 2021, the law was changed. Previously, the director of ED could have held office for a term of not less than 2 years, just like CBI director. But in 2021, the law was amended. And the amended law, just like it was amended for CBI. How? CBI director appointed for 2 years. But can CBI director be given extensions? 1 year at a time. Total 3 extensions. So that combined term is not more than 5 years. Similarly, in 2021, same year, amendment was done, according to which ED director is appointed for 2 years, but then can be given 3 extensions, 1 year at a time. But on what grounds? In public interest. And you have to tell us the reason why you are giving extension. For example, when one particular director of ED was given multiple extensions, matter went to the court. Prashant Bhushan approached the Supreme Court. Supreme Court asked the government, why are you giving him extension? The government said, because we are under review by Financial Action Task Force. Because this is the global body which keeps a check on the systems in different countries, whether your systems breed money laundering or whether you are compliant with anti-money laundering laws. Since review is under order, we need the same ED director to help us with that review. That is why 3 extensions can be provided, but total, it cannot be more than 5 years. Under PMLA, there is a reverse burden of proof. And what is this reverse burden of proof? Normally in a criminal justice system, you are innocent until proven otherwise. But in PMLA, it is reverse. You are deemed guilty. You have to prove that you are innocent. That means the burden of proof is on the accused, not on the prosecution. That is why bail becomes extremely difficult in PMLA cases. And if a bail is to be granted, there is something called twin test for granting bail. What is that twin test? If I am accused under PMLA, I apply for bail. Law says, PMLA says, that court should not grant me bail unless and until you hear the public prosecutor. You hear the government lawyer. Basically, you hear the Solicitor General of India, for example. And the court can give me bail only if 2 conditions are satisfied. Condition number 1, the court believes that I am innocent, or the court has reasonable grounds to believe that I am innocent. And if I am released on bail, I will not be committing any further crime. I am not likely to commit any further crime. Now, why does it make bail difficult? For example, I am your teacher. You are using smartphone 17 hours a day. Your father comes to me and says, I have confiscated his phone. Now I will not give the phone back, smartphone back, because he does not study for the prelims examination. I convince your father that please give smartphone back because he needs to watch YouTube videos. At least my videos he should watch. Your father tells me, give me in writing that he will not misuse the phone. Now, why would I give it in writing that he will not or you will not, I don't even know you, that you will not misuse the phone? Why should a judge keep it on himself that I know you will not commit any other crime if I release you on bail? So that is why it becomes difficult to get to be granted bail under the PMLA cases. And how do I know whether you are innocent or guilty? Innocent or guilty comes after the trial is over. Bail we are talking about even before the trial has begun. That is why this twin test is extremely difficult. That is why bail under PMLA is extremely difficult. But there is an exception. If a person is under the age of 16 or is a woman or is sick or infirm, bail can be granted by the courts. That is how K. Kavita was granted bail by the court. Why? Because she is a woman. So woman sick, infirm, or somebody who is under the age of 16. Not 18, 16. So if this statement is asked in the examination, you should not assume that since it is not 18, so it may be incorrect. 16 is correct. A person less than the age of 16 can be released on bail. But there are similar laws which have similar provisions where you are deemed guilty. You have to convince to the court that you're innocent, where there is a reverse burden of proof. For example, the Drugs and Cosmetics Act 1940, NDPS, Narcotic Drugs and Psychotropic Substances Act 1985, and UAPA, Unlawful Activities Prevention Act 1967. Right or wrong? Right. 10th body, National Integration Council. Way back in 1961, Pandit Nehru was the Prime Minister. A conference was organized called National Integration Conference. What this conference debated and deliberated upon? That there are some evils in our society: communalism, regionalism, linguism, casteism, narrow-mindedness. How do we formulate response to all these evils in our society? Because these evils have the potential to disintegrate our society. We want to integrate our society. And that is how this conference suggested that we should set up a National Integration Council. And that is how National Integration Council was set up in 1962. But is this body mentioned in the Constitution? No. Is this body created by any law enacted by the Parliament? No. Which means it is not a statutory body. It is not a constitutional body. It is extra-constitutional, non-statutory body. But the thing about National Integration Council is that its composition was diverse. Prime Minister, Union Ministers, Chief Ministers, journalists, civil society activists, academics, writers, film stars, they were made part of this National Integration Council. But the last meeting that took place of this council was in 2013. That is why some people demand that this committee be reconstituted. But it has not been reconstituted. Nevertheless, can be an important committee for your examination. Then we have zonal councils. Topic number 10. States Reorganization Act was passed in the year 1956. Because prior to this, we had Group A, B, C, D territories. When this law was enacted, this Group A, B, C, D differentiation was done away with. 14 states and 6 union territories were created. At that time, Pandit Nehru said, why don't we reorganize the country into various zones as well? Because different zone may have different peculiar problems or reasons or demands or challenges. Because that was the time when there was linguistic bitterness. Because states were created and carved out in the name of language. And that linguistic bitterness had the tendency to threaten the unity, integrity, sovereignty of the nation. And that's how it was decided that we will create zonal councils. Let's club these states into zones: northern, central, eastern, western, southern zone. And all these 1, 2, 3, 4, 5, these are 5 zonal councils, which means these are statutory bodies established under the States Reorganization Act 1956. But then the year was 1972, another act was enacted, Northeastern Council Act 1972. Now, northeastern states, 7 sisters and Sikkim, they were removed from the existing zonal councils. A separate zonal council was created for them called Northeastern Council Act 1972. Are union territories also part of these zonal councils? Yes. Union territories are also part of the zonal councils. Who is the chairperson of all these zonal councils? Home Minister. Who is the vice chairperson? Chief ministers of the states in that zone by rotation. That means for 1 year, the chief minister of Tamil Nadu may be the vice chairman. Then Mr. Revanth Reddy may be the chairman for 1 year. Then Mr. Siddaramaiah, if he survives as the chief minister till that time. But members, chief minister and 2 other ministers as nominated by the governor. 2 members nominated from the union territories. Which means chairman is home minister. Vice chairman is chief minister of one state. Other members are remaining chief ministers and 2 other ministers. Who nominates them? The governor. Can other union ministers participate in these meetings? Yes, depending upon the necessity. Whether it is required, then other ministers can also participate. But Northeastern Council Act was passed in 1972. How many zonal councils we have? 5. Northern, Southern, Eastern, Western, Central. Northeastern Council was not enacted under the States Reorganization Act. A separate law was enacted in 1972. And this law was amended in the year 2002, and this question has been asked in, I think, 2024 prelims examination. Northeastern Council means northeastern areas, which includes Assam, Manipur, Meghalaya, Nagaland, Tripura, Arunachal, Mizoram and Sikkim, which means 7 sisters of Northeast and Sikkim. What is the composition? This council will have governors of the states mentioned above. All the governors will be part of it. Chief ministers will also be part of it. And 3 members nominated by the president will be part of it. Now listen to me carefully. Who is the chairperson of the Zonal Council? Home Minister. Who is the current chairperson of this Northeastern Council? Home Minister. But does Home Minister necessarily have to be the chairman of the Northeastern Council? No. Why? Because the law says President will nominate the chairman of this Northeastern Council. And you don't have to be even a member to be nominated as the chairperson. That means a non-member can also be appointed as the chairperson of this committee. Since Home Minister is not the governor or the chief minister of these states, but you can be appointed either a member or you can be directly nominated as the chairperson of this council. And this council has now been called as a regional planning body. Now comes the 11th one, NITI Aayog. It was set up in 2015. Now it has completed 10 years of its existence. And it becomes a potential question for your examination. It is now into its 11th year. It is not a statutory body. It is not a constitutional body. It is extra constitutional, non-statutory body because it is created under the Government of India Allocation of Business Rules 1961, which means it is created by a government resolution. Government resolution. This NITI Aayog has a governing council. We say NITI Aayog is the think tank of the nation. The job is to create policies, research, rank the states, advise the states. The predecessor of NITI Aayog was Planning Commission. Planning Commission was heavily criticized because it has concentrated powers to itself. It was creating the 5-year plans, making these 5-year plans. Although they would not be approved by Planning Commission, that used to be approved by National Development Council. But the thing, when Mr. Modi became the Prime Minister, he said, I want to transform Planning Commission into a truly federal body. And that's what he did. In 2015, Planning Commission was replaced by NITI Aayog. NITI Aayog's governing council consists of Prime Minister, Chief Ministers of all states, all the union territories with legislature, Lieutenant Governors of other union territories, some ex-officio members, Vice Chairperson, NITI Aayog's full-time members, special invitees. This is the governing council. Because NITI Aayog consists of chairperson. Prime Minister is the chairperson of the NITI Aayog. It will have a vice chairperson. And recently somebody from Bengal was appointed as the vice chairperson. It has a chief executive officer. It has full-time members. It has special invitees. It has some ex-officio members. And together they are part of this think tank called National Institution for Transforming India, known as the NITI Aayog. This brings us to the closure of this video. I hope this video was of help for you. The PDF will be provided in the Telegram channel. Please revise it a couple of times. Expect at least one or couple of questions from this video. Till then, all the best. Bye-bye. Take care.